Bill Zimmerman and ABC News correspondent Virginia Sherwood.
Well, I'd like to start, first of all, and I could direct this at both of you, but I think mainly it'll probably be for you, Mrs. Schlafly, and that is the quotation we started the show with: equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Now, you are with Stop ERA. Why are you against this?
Well, the language of the amendment, I think, shows why we didn't find out what was the matter with it until we got well into this constitutional debate. Most people thought it meant equal pay for equal work, but that's now already guaranteed by the Equal Employment Opportunity Act of 1972. But we have found that the Equal Rights Amendment will take away from women some of the most important rights that they now possess. For example, the laws of every one of our 50 states require the husband to financially support his wife and children. Now, under the Equal Rights Amendment, all these laws will be invalidated because no longer can you have any legislation which imposes an obligation on one sex that it does not impose on another. You don't have to take my word for it. The principal piece of scholarship used by the proponents is this article in the Yale Law Journal by Professor Emerson, where he says clearly that after the Equal Rights Amendment is ratified, the courts would have to strike down non-support laws which impose the duty of support on men only. Now, this takes away from the wife and mother her legal right to be a full-time wife and mother and to bring up her baby in her own home. And I think that's the basic and most fundamental right women have. Then you move into the second area, which is the area of the draft. Of course, as you know, women are not subject to the draft like men are today. There's no dispute about the fact that the Equal Rights Amendment will positively make women subject to the draft and on an equal basis with men. And again, we can refer to the same law journal article used by the proponents in congressional debate and in state legislative hearings. And it's spelled out in page after page of how women will have to carry the same 40 to 50 pound packs. Women will be sent into combat on an equal basis with men. You couldn't even exempt mothers unless you also exempted fathers. And as this article says very clearly, neither the right to privacy nor any unique physical characteristic justifies different treatment of the sexes with respect to voluntary or involuntary service.
Well, can we talk about these two points with you, Congresswoman Schroeder? Are you in favor of knocking down the support laws and in favor of drafting women, for example? You're pushing this amendment.
I've read the Yale Law Journal very closely, and also I'm a lawyer and have practiced very heavily in this area. I think she is misinterpreting it and taking it out of context. Let me basically say what the Equal Rights Amendment will do, and I think almost every lawyer in the country agrees. Right now there are support laws, but there is no court in the country that will enforce support laws while a marriage is going on. And if you don't believe me, you can ask any woman who's had trouble with their husband supporting them, and you go into court and say, my husband's not keeping me in the way I'd like for him to, and they're going to say, we don't touch that lady once the marriage is going along. They will never step in during the marriage. So if it's unfortunate enough that it comes to that kind of situation, the courts won't step in. And I think understandably so. Sometimes it's regrettable, but if they do step in, what instantly ends up happening anyway is you go to a divorce. So if a woman is married to a man who refuses to help support her, she's really forced to go to work anyway or seek a divorce situation. Now, if you want to talk about the support laws after the marriage is broken down, then there is some justification to what she's saying in that it will not just be the man's role. But most states have moved to that anyway. Like I live in a state where that's happened, and they look at the total picture. They look at both people, their education, their backgrounds, how they might be employed, if they are employed, what they're doing, the age of the children, the whole picture.
Is that considered ability to support?
Ability to support by both parties. And if there are young children in the family and the mother is staying home, then the father would be expected to support at least for a certain period of time. However, if she has her college degree and she's working, she's not going to. As you probably know, in less than 2% of the cases in the country right now is any alimony given on a permanent basis. Because of that reason, we're growing, and you can't ever take one income and fully sustain two households.
Well, in other words, what you're saying is that the wife should give up her legal right of support right now in turn for what the court may decide in her particular case. Now, American jurisprudence, too, spells out very clearly the wonderful rights that a wife has under our laws. I appeared at the Missouri hearing with Professor Emerson, and he did not deny the quote that I have just given you, and it's hearing after hearing in state legislatures around the country. Lawyers for the proponents have come in and said, yes, we do want to eliminate the sole obligation on the husband to support his wife and family, and we want to make that obligation fall equally on the husband and wife. Now, this equality is a gross step down for American women, and in most cases they don't even have to go to court to enforce this right of support. It's in the laws or the statute or the case law of every state, and a woman in every business place knows that they can collect the bills against the husband because the husband is required to support his wife.
Well, do you think that women should be able to collect the bills, even if it is the woman rather than the man who has the money, for example?
I think that the man should be required, as the law now says, to support his wife and children. And yes, the bills that she makes, he ought to have to pay for. It's based on a very fundamental premise that...
That's sort of a female chauvinist pig.
Well, the women have the babies. You can't change that fact. You can't make the men have the babies. And so if you enforce a legalistic equality of support on the husband and wife, you're really giving the woman a de facto double burden.
But I think you're confusing it in a way, in that there's what you're saying he said is true, but he went on to spell out just what I said. In other words, you're correct that they will look at both sides, but if the woman has had a baby and is home taking care of the baby, and she may have a PhD degree, the courts are still going to require the husband to support the woman if she's home taking care of the baby. Then...
Well, that's your prediction as to what the courts will do, and you have no way. Who knows what the courts are going to do?
Because we have many courts that already have that law in effect, including Colorado.
Because of the laws that are now on the books. And the laws now, they give all these wonderful rights to the wife, and the courts have to interpret it in that basis.
Now,
if you wipe out the primary obligation of the husband to support his wife, then the wife's got to take her chances on what the court...
I'd like to ask a question so that we can, instead of going back and forth on this thing, I would like to ask right now, Mrs. Schroeder, you have brought up the fact that there are laws in Colorado, and Mrs. Schlafly has been saying some states have these laws or it's already taken care of. Mm-hmm. Now, I want to know legally, if the Equal Rights Amendment is passed, is ratified by the states and becomes law.
Women will not be forced out of their homes to work.
All right, but what are you saying legally? Is there precedent for the fact that, as you say, if the woman, regardless of her financial earning ability, regardless of her education and so on, if she has a small baby in the home, you are saying that there is precedent that no court is going to send her out to work to support that baby if she has a husband to support it?
If she has a husband to support it. Now, if she doesn't, then they will hold the support laws against her, too, because, you know, she should be trying to support the child. And we do that right now, and we have many, many single-parent families headed up by women who certainly are trying to support their family. But what I'm saying is it's not going to instantly take all marriages. See, what I think I hear you saying, and I'm not sure, but I think I hear you saying that instantly they're going to step into all marriages and say, okay, it's 50-50 support, and if there's a baby, you have to work anyway.
No, they're always, women are going to be able to sweet-talk their husbands into doing more than the law requires. But the high divorce rate shows that many women do need the law to make the husband fulfill his obligations. And you're just giving us your opinion as to what the courts may do in the future. But the constitutional authorities, such as Professor Paul Freund of the Harvard Law School, have said clearly that the Equal Rights Amendment dictates a principle of family support which is contrary to the laws of every one of our states. Sure, a wife still may be able to get her husband to support her, but she's lost her legal right. The legal right she has now, regardless of her ability to support herself or regardless of her independent means. And that is the law in every state. And that's
Excuse me, ladies. We'll get back to this and also to the draft question in just a moment. We'll be back with more issues and answers.
Now I believe that perhaps, Ms. Schroeder, you would like to answer what Mrs. Schlafly just said about the law.
I'm very aware of Professor Freund's arguments, and what he's really saying is he would prefer to do it in another way. The amendment has been changed so that it will help anyway. It gives states 2 years to bring up their legislation rather than creating chaos, which I think answers a lot of his criticism. But on this whole right to support, as I say, there's no court in the country right now that will enforce a right to support if the husband won't do it. So you're really faced with having to persuade him right now anyway. If he won't support, then you're faced with the divorce thing. Most of the courts right now are going on capacity to, sustain yourself. And
so are you saying that women will be as well off after the ERA is ratified as they are now?
I think so, yes.
All right, let's move on then. That's
okay.
You believe they won't be. She believes they will be. I think we've kind of exhausted that right now. If we could move on, I believe you made statements about the draft, which we don't want to go all over again, Phyllis, but would you like to sort of sum that up quickly, and then we'll let Pat
Well,
answer?
yes. There isn't any dispute about this. In hearing after hearing, the proponents come in and say, yes, they do want women drafted on exactly the same basis as men. And I know, according to every poll that's ever been taken, this is not what the majority of American people want. Now they say the draft is going out. We've had a draft for 33 years, and we've had 3 bloody wars that nobody expected, and most of the time the politicians were promising peace. The point is that if we have ERA, we have this constitutional millstone around our neck, whereby if we have a national emergency, we then are saddled with this social upheaval. And we do not want women serving in combat and on warships on an equal basis with men.
I'd like to answer that, if that's okay. First of all, as you probably know, less than 14% of our troops right now are in any kind of ground combat, and all the rest of the drafted positions are in some other phase. Right now, Congress could draft women anyway. They have that right in the case of a national emergency. World War II, in England, they drafted women. The draft is going out. She's correct about the volunteer status. But the other thing that I think that we keep overlooking, too, is that we're entering a new phase because of technology in the whole fighting of wars. It's more a push-button technology type of thing. But when you boil all that down, we still have always had different kind of deferments, etc., within the draft. We've allowed, families to stay together, no more than so many members of the family having to go, fathers allowed to stay home under certain conditions. I'm sure that these kind of things will continue to be in existence. This has been in our history for years and years and years.
Well, aren't you on the one hand arguing in favor of equality for women, and on the other hand saying you're going to reserve the special
No, I'm saying we've had the special privilege for men. As it's, in certain circumstances.
But it's been a little more special for women.
It's
more special because
and this matter of technology, tell that to the POWs just coming back from Vietnam, or tell that to the 45,000 men we lost in Vietnam. Who would have thought we would have had Vietnam? And we would have to subject women to it on exactly the same basis as men. Now, Pat said that Congress now has the power to draft women. Well, that's right, but Congress has used that power in order to exempt women, and that's the way we like it. The point is that under the Equal Rights Amendment, Congress will no longer have the option. Congress will be constitutionally required to draft women on the same basis as men.
Do you agree with that, Congresswoman Schroeder?
I agree that we have the power, that, whether or not we will continue to use it depends on the state of emergency.
Do you agree that you'll have no option if the Equal Rights Amendment...
That's right. We will have to put laws in that apply both to males and females equally. In other words,
you want to draft women?
That you can only draft women for combat duty if they can perform the same functions and men and women would have to be equal.
Do you think that's desirable?
Yes, I think that's all right.
I'd like to turn.
A woman in combat is a desirable thing?
I think it's brutalizing. It's brutalizing to any human being. I certainly don't wish that anyone has to put themselves in that situation. But I think that all of us have, we're all Americans down under the skin, and we all have certain rights and responsibilities. And I think that the Congress can deal with that. I think we can still make it so we're not tearing up families. We've never done that. I think that can all be dealt with, and I think that it's just not...
well, that's the language Dr. Emerson used in the Yale Law Journal, and he said if we're going to brutalize young men, we might just well brutalize young women, too. Let's be equal about it. But I don't think the majority of Americans want that.
Well, I would like to ask a question, and I'd like to move a little bit away from the draft, but we've been talking about the administration, the Congress. People have been telling you this, and they've been telling you this won't happen. Now let's talk about the leader of the country, the President of the United States, who has come out for the Equal Rights Amendment. You're a Republican. You consider yourself a conservative Republican, yet you're on absolutely opposite sides of the fence. Pat Schroeder, a Democrat, is on his side. Why is this?
Well, I think this is an issue that cuts right across both political parties and all the ideological spectrum. The Founding Fathers, in their wisdom, gave no part in the amending process to the President of the United States. He cannot sign it. He cannot veto it. It's simply out of his jurisdiction. The amending process goes from the Congress to the state legislatures, and the President has sent no message to the state legislatures. He is smart enough to stay out of that, and he's, of course, entitled to his opinion. But it's not an opinion that need be binding in any way on anybody.
Isn't a message by the President to the Congress and a public message by the President, isn't that a message to everyone in the country?
Why, the way this has been used at the hearings is that a representative of Common Cause comes in and reads an old letter from the President from which they have carefully deleted the date.
But
and
I'm thinking of a recent statement,
yes, he put it in the State of the Union message to the Congress just this week again.
Well,
he reiterated his support. And I think when you're reiterating as part of the State of the Union, it's a pretty general mandate.
It's very interesting that the proponents are not using this in the hearings because it's such a qualified statement, and they are using this old letter, which they've deleted the date, in order to, I think, not represent the President properly.
Well, I think, of course, they haven't been able to up until this time, Phyllis, because the President just made this the other day.
Well, he has no part in the amending process. It's simply out of his jurisdiction, and it's now in the hands of the state legislatures. And I think based on the facts of how this amendment is so hurtful to women, we've had more state legislatures reject this year than have ratified. And there are now 8 states that have rejected this year. In fact, I think it's 9.
Mrs. Schlafly, if it is, as you say, not very popular among American women, how do you explain the fact that both houses of Congress ratified it by very large numbers, and that 28 states already have ratified it within a little over a year?
Well, I think that's a very interesting question. You know, the House committee that took the testimony and held the hearings did not pass the Equal Rights Amendment in this form. In fact, in talking about the Equal Rights Amendment that we are now considering, the majority House report said not only would women, including mothers, be subject to the draft, but the military would be compelled to place them in combat units alongside of men. The same rigid interpretation could also require that work protective laws reasonably designed to protect the health and safety of women be invalidated. In some cases, it could relieve the fathers of the primary responsibility for the support of even infant children, as well as the support of the mothers of such children, and cast doubt on the millions of support decrees presently in existence.
Well,
now, it was only after it went on the floor of Congress that the men who did not hear the testimony struck out the qualifying clause that the majority of the House committee put on.
Okay, Mrs. Schroeder, we'll get back to you. We're going to interrupt you again. We'll be back in just a moment with more issues and answers. Point when we left that this amendment was changed drastically between the time it was in committee and the time that it was ratified. Do you think that the changes were good, or did they in fact occur, as Mrs. Schlafly told us?
Well, she's referring to the Wiggins Amendment, which was attached to the amendment in committee. As you know, committees are controlled very heavily by their chairman, and the chairman of the Judiciary Committee, who was in charge of the ERA, had been very successful in keeping it from ever getting out before. And it was kind of a way to get it out, as I understand it. It was kind of a maneuver, just finally to get it out, because they were getting so much pressure of stop burying it. It's kind of a nice way to avoid taking up issues you don't want to. So it was kind of a compromise to get it out so you could at least get it on the floor. Then the Wiggins Amendment was done away with, and I think rightfully so. I think most of us felt that when you look at the country as a whole, there's just no question that women have been denied equal rights. And we're not talking about making the sexes equal. We're talking about treating the sexes equally, you know. And there's a big difference between that. And I think so many people think that they're trying to legislate that everyone will be the same. But when the legislators really started looking at what it was going to do, and the lawyers were testifying, etc., it became very clear that it was, you know, certainly long overdue, and it was not threatening at all.
Well, let's be real clear about what the Wiggins Amendment does. The Wiggins Amendment specifically exempted women from the draft. And so when they took that out, that shows they mean that they want to draft women on an equal basis with men. And during most of the rest of the years that the ERA was in Congress, it had attached to it the Hayden modification, which said, nothing in this amendment shall be construed to deprive women of any of the rights, benefits, or exemptions they now possess. Now, why do they want to deprive women of the rights, benefits, and exemptions we now have?
The question is, who's interpreting what the rights, benefits, and exemption are? What you might think is a benefit to me, I might not think is.
Well, there's no question but that the majority like the exemption from the draft. And I certainly, if you put it up to a vote of the women, the majority would like the right of a woman to be supported by her husband. And then you've got other benefits, such as the preferential benefits.
Those are both, those are both.
I would have to say that I can't make that same statement because I don't know how the majority of the women in this country feel about the draft, or do I know how they feel about the fact that they think their husbands should definitely support them. I cannot say that. But we were talking about making things clear, and I feel that since we're talking about a statement that the President of the United States made, the State of the Union on Thursday, that perhaps I ought to read this little segment so that everybody would know what we have been talking about, if that's all right with you ladies.
Please do, yes.
It says, the role of women in our economy is bound to grow, and it should, not only because the expansion of opportunities for women is right, but also because America will not be able to achieve the full economic potential unless every woman who wants to work can find a job and provide their compensation and equal opportunity for advancement. Is there anything in that you could disagree with?
No, and I'm glad you brought that up, because that shows that many people think that the Equal Rights Amendment is going to give employment opportunities for women. Now, I've been to 10 of the state legislative hearings, and the proponents have absolutely given up claiming that ERA will do anything in the field of employment for women. And they admit, and their lawyers admit, that there's nothing ERA can do in the field of employment which is not already done by the Equal Pay Act of 1963, the Civil Rights Act of 1964, but most particularly the Equal Employment Opportunity Act of 1972, which is so specific and which is what required AT&T to make its $38 million settlement to women.
I think that what you're missing is the fact that the one major thing the ERA will do that none of these things can do is it opens up educational opportunities. There are many schools that are state-funded or federally funded that are limiting the number of women in the graduate schools, that are limiting the number of women in the undergraduate schools. There are many professions that are still limiting indirectly through that type of procedure. There's many the academies. We say we want women to enlist before we even get to the draft. However, they can't go to the academies, which means that they're shut out of really getting into the policy-making stream if they choose to make that their career. I don't, but for someone who does, I don't think that I should tell her that she's being benefited because I've made the decision for her that she shouldn't do it.
So there are not many. There are a few, but
and indirectly that increases the jobs because you suddenly have more women that are qualified. When we're looking at a country that's got 7% of the doctors being women, and that's the most. It goes right on down to 1% of the engineers. You know, that's it professionally. And you look at the quotas and you look at the things that are happening, we've got to open those doors. The saddest thing that was ever said to me during my campaign was I had a 6-year-old girl say to me, I think it's very interesting you're running for Congress, but I want to be a Russian. And I was horrified. I said, what do you mean you want to be a Russian? Because I thought, 6 years old, how can they be at all politically astute? And she said, well, I want to be a Russian because I want to be a mommy and an astronaut. And you can't do that in this country.
Oh, no.
I found that very touching.
We have less than a moment
really
left.
True. I'm sorry.
Less than a moment. I'd like to get from each of you very quickly how you think it's going in the states, whether you think your side will prevail and why, just briefly in perhaps 10 seconds each. Mrs. Schlafly?
Well, I think it's going great because more states have rejected this year than have ratified. But I also want to say that if there are a few states which limit the educational opportunities, you have to balance that with the other states where the women's property rights are so superior to men, where women have the wonderful dower right.
No, I don't think that's right.
Well,
I do. I'm sorry.
Being
aware. I think that we're really looking very good. I mean, we do have 28 states that have ratified. We only need 10 more. We've got, several years in which to work in it. We're right where we were when we were trying to get the franchise.